All right, very good. Can everyone hear me? You can give me the thumbs up. All right, great. So, welcome everyone to the House Committee on Judiciary Non Civil. It's an honor to have everyone here with us today and appreciate your time. The purpose of the series of hearings that we're going to have are to review initially Georgia's Citizens Arrest Law, OCGA 17 4 60. This summer, we're going to hold a series of committee meetings to review and consider the Citizens Arrest Law, and we will hear testimony about what the law is and whether it should continue to remain in the code. I expect we're going to hear from many different Georgians on this issue with differing perspectives, and committee members are encouraged to ask questions of those testifying. If you would just use the raised hand feature on Zoom so that I can identify those who have questions. Also, if you would please make sure to mute your speaker, or House Media Services will help with that, just so we reduce background noise. For planning purposes, our next committee meeting will be via Zoom on July 23rd at 10 a.m. and future hearing dates will be sent to committee members by email and posted on the meetings notices page of the Georgia House of Representatives website. So at this point in time, we'll go ahead and get right into our first speaker. I appreciate the opportunity to have Gwinnett County District Attorney Danny Porter with us here today, who can maybe explain to us what the Citizens Arrest Law is, give any information that he might have about how he's seen it in practice and use, and what his thoughts are about the statute in general. District Attorney Porter, will turn it over to you now.
I'm unmuted. First of all, my name is Danny Porter. I'm the district attorney in Gwinnett County. I want to make sure everybody understands that I am not here on behalf of the District Attorneys Association of Georgia or the Prosecuting Attorneys Council. I was invited by Representative Estration for the purpose of giving some information to this committee, and that I was happy to do that. And I want to make one second point, is that in my legal opinion, the Ahmaud Arbery case is by no means or by any interpretation a use of the Citizens Arrest Law. So those are the two prefaces that I have. Citizens arrest is a concept that comes down to us literally from medieval times. During that time, before the organization of police forces, citizens were empowered, actually were given an affirmative duty to detain and hold criminals for government officials, usually sheriffs, that came and got them and brought them before the King's Justice or before a grand jury after the Magna Carta. But our law in Georgia began in 1833. It was contained in the first codification in 1833. It was subsequently amended in 1864, and basically what we have now in OCGA 17 4 60 tracks the language of the 1864 amendment. Basically what citizens arrest says is that a citizen can conduct a arrest for a crime that occurs in their presence, or if that crime is a felony, they can, well, it has to be a felony and the person is trying to escape, they can conduct that arrest based on reasonable and probable grounds of suspicion. In other words, they could, in terms of a felony, they could make an arrest based on the same probable cause that would support a warrant if a police officer went before a magistrate and issued and asked for the issuance of an arrest warrant. The real problem is that nobody consents to an arrest. An arrest necessarily requires some degree of force, and whether it's just come along with me and you put your hands on the person's arm, or whether you have to fight them into a patrol car, police officers will tell you that there's some degree of force in every arrest. And so the real question is what level of force can a citizen use to effectuate that arrest? And right now in Georgia, it says that you can use the reasonable force necessary to effectuate the arrest and to detain the individual. Although courts have held in a 2004 case that in that case, a shopkeeper shot a person who was in the store and refused to remain. And the court, and then he tried to claim that he was making a citizen's arrest for a felony theft. And the court ruled that was a disproportionate use of force under the circumstances of the case. There was a second case, there was another case where a person pursued a burglar and beat him with a baseball bat, and the court held that was a disproportionate use of force. So I would say that the use of deadly force is frowned upon in the courts, and certainly it shifts the analysis from a citizen's arrest to a defense of self or defense of others. I'm, along with Mr. Paul Bowden, I'm the longest serving district attorney in Georgia, and the cases that I've had with citizen's arrest, and I'm going to exclude two big categories here. One is shoplifting by arrest by loss prevention officers, and the other is in the defense of home by homeowners. But the other ones, frankly, they remind me of the Andy and Mayberry episode where Gomer Pyle was going around trying to make citizens arrest, and they usually turn out badly. They usually are with someone's misinterpretation of the law, or I've even seen them where they've attempted citizens arrest for noise violations, or which is of course not permitted. It has to be a violation of state law. So citizens arrest in this age of increased police forces is really kind of an outmoded concept, except, as I said, in the two areas that I wanted to exclude, which was merchants being able to make some type of citizen arrest, and then homeowners being able to defend their property. In the case of the merchants, they have non-sworn loss prevention officers. So literally every detention that a merchant makes of an individual for shoplifting is a form of arrest, because in Georgia, arrest is defined as where a person is detained for longer than a short, or they use different terms, immediate, short period of time, their freedom to move about. And so when a loss prevention officer walks up to a person in a store and says, come back to the office with me, and they search the shopping bags, that's an arrest under Georgia law. And you know, the question is it a policy decision to empower those people to make those types of arrests? Because sometimes they do end up in use of force situations. The other one that immediately came to mind, and I was discussing this with Reverend Woodall, is if you remove the power of citizens arrest entirely, then I can think of a hypothetical where you've created a policy situation where it is to my legal benefit to kill someone than it is to detain them. And that would be a situation where I wake up in the middle of the night and I go out and I capture a burglar in my house. Well, if I'm not allowed to make a citizen's detention of that person, then there's no incentive for me to not shoot him, because I would, under our self-defense laws, I would be justified in shooting him. So, I mean, I don't know that I'd be thinking that rationally at that point, but I think it highlights that there may be a conflict between the right to defend yourself and the citizen's arrest law. So I think that's something that needs to be looked at by the committee. I'm not advocating one way or the other. but I think it could create a potential problem. The other question was, what's the statutory process to effectuate a citizen's arrest? Actually, it's contained in 17.4. It talks about that the citizen can detain and hold the person. There's no specific requirement that they be brought before a magistrate or a committing judge with any certainty or any time period like there is for a warrantless arrest for a police officer. So it's really unclear what the statutory process would be once hands are put on, and it's left to a lot of the individual jurisdictions. For instance, in Gwinnett County, we require that the merchant call the police. The person is transported to the jail based upon the statement of the merchant, and the merchant has to come to the jail within a certain amount of time, and I don't remember what it is, to actually swear out the arrest warrant. And if the merchant doesn't show up by then the citizen is released. So it's probably unique to every jurisdiction about how they handle these merchant arrests or citizens arrests. As far as I can tell, citizens arrests are not individually reported in the GBI crime data that's compiled annually. It doesn't appear to be reported in the FBI statistics. GBI turns them over to FBI. There doesn't appear to be any distinction between citizens arrests and law enforcement arrests. And then the last question I was asked was, would repealing have some effect on the law of defense of self or others? And I think, other than the example I used, there may be a potential effect on that that would have to be considered in any. I think you'd have to account for it, I guess, is what I'm saying. Is and let me just end by saying I'm personally not in favor of citizens arresting one another, but I think we have to be a little bit careful of that. There may be some collateral effects.
Thank you, Mr. Porter. Would you mind expanding on what you were saying about potential application in the Arbery case, in your opinion? And also, if you can talk about any specifics of the training that goes into law enforcement and loss prevention officers and folks like that who are detaining individuals, and how that training component might or might not be something that needs to be considered when a law like this is on the books.
Well, now again, this is my opinion, but in my opinion, based on the information I know, in the Arbery case, there was, even if you, first of all, there was not sufficient probable cause or suspicion to believe that a crime had occurred. Therefore, there was no justification for pursuit and detention. As far as I can tell, the most serious crime that could even potentially be considered was some type of trespass or entry onto a property, even if that existed. And it doesn't seem like it does, because the homeowner apparently had never complained about it or had never made any comment about it. So, for instance, we've got a house under construction in my neighborhood. Every day I drive by, there's somebody walking in there. There's a car pulled up, and there's people walking in, checking it out. And I don't even know that builders consider that even a trespass. So, when Mr. Arbery ran by, at that point, it appears to me that and that the defendants did not have even reasonable suspicion that a crime had been committed. Therefore, they had no right to make the arrest. And that seems to me to be the basis of that case. As far as training, police officers receive mandated training through the Peace Officers Training Council, and we do address, there's about a 4-hour block on laws of arrest. Because it's focused on police officers, it generally focuses on their procedures. We address citizens' arrest in it. But frankly, there's not a lot to address in citizens' arrest. There's some case law and there's the statute as we have it. As far as loss prevention officers, I'm afraid I don't know the answer to that.
All right, I don't see anyone using the raise hand feature. So thank you, Mr. Porter. We really appreciate you being with us today and the insight that you were able to provide. We'll next hear from Marissa Dodson with the Southern Center for Human Rights.
Thank you. Good morning. Again, my name is Marissa McCall Dodson. I am a lawyer and the Public Policy Director at the Southern Center for Human Rights. It is because of our continued advocacy for fairness, justice, and dignity in the state's criminal legal systems that we join in the call for Georgia's citizens' arrest laws to be repealed. Both the Georgia and U.S. constitutions recognize the importance of preserving liberty by prohibiting anyone from being arrested unless there is probable cause to believe that he or she has or will commit a crime. This protection from unreasonable arrests that is enshrined in the U.S. Constitution's Fourth Amendment and in Article 1, Section 1, Paragraph 13 of Georgia's Constitution has resulted in hundreds of thousands of pages of state and federal case decisions, the precedents of which are used to inform the training law enforcement officers in this state receive on lawful arrests. I will let the law enforcement representatives who will provide remarks to the committee go into the specific training officers receive on arrests. But I do think it is important to note that every law enforcement agency in this state requires that an officer is certified by the Georgia Peace Officers Standards and Training Council, known as POST, before conducting arrests on behalf of the agency. Excuse me. By contrast, every private person in Georgia is given the power to conduct a warrantless arrest without any training or certification. Before the citizens' arrest statute was cited as a justification for the killing of Ahmaud Arbery earlier this year, most Georgians had no idea that our laws give private persons and law enforcement essentially the same powers to arrest. Plainly stated, the law allows a private person to arrest another in two circumstances: for misdemeanor offenses, when the offense occurs in the person's presence and the arrest is done immediately, and for felonies, when the person has reasonable and probable grounds to suspect the person has committed the crime. This was used as a justification by a prosecutor in the Ahmaud Arbery killing. Once a private person has made an arrest, Code Section 17-4-61 requires that the accused be brought before a judge or a peace officer without unnecessary delay. This authorization to transport a person from one place to another poses significant risks to Georgia's residents, both to the persons conducting the arrests and to the persons being arrested. In addition to the substantial risk of physical harm, people who conduct citizens' arrests also expose themselves to civil liability for the tort claims of false arrest and false imprisonment. It is important to note that the citizens' arrest statutes can be repealed and certain lawful detentions by private persons can still occur. This situation comes up most in the context of theft crimes at retail establishments and is widely known as the Shopkeepers Privilege. Though the citizens' arrest statutes are currently used to justify the detention of people suspected of stealing goods or services from a business, in practice, the arrests are being conducted by trained law enforcement officers who respond to a location where an accused person is being detained. These detentions can remain lawful without providing arrest powers to private persons. Finally, it is worth clarifying another common point of confusion about citizens' arrest laws. Often when I speak to people about the need to repeal the law, someone will say, well, without citizens' arrest, what would a person be able to do if they saw someone being raped or assaulted? Or what could I do if someone breaks into my house? The simple answer is this: repealing citizens' arrest laws have nothing to do with the state's self-defense laws, and to repeal it would have no impact. We could essentially, and probably should, clarify the duty to contact law enforcement when someone is defending themselves. But again, citizens' arrest and self-defense are not the same. Code Sections 16-3-21 through 16-3-24 lay out Georgia's laws on when and how someone can use force to defend themselves or others. Irrespective of the law on citizen's arrest, someone can use or threaten force when he or she reasonably believes that such threat or force is necessary to stop the imminent use of unlawful force. As you know, deadly force can be used in self-defense, and this has nothing to do with whether either person had the power to conduct an arrest. We at the Southern Center are very interested in a discussion about the appropriateness of the state's self-defense laws and the potential for reforms, but it would be misplaced and confusing to try to have those conversations simultaneously with that of citizen's arrest. The law that grants private persons the broad authority to arrest is archaic and must be repealed. No person should be authorized to conduct an arrest of another in Georgia unless he or she is a trained law enforcement officer. Citizen's arrest was first created when law enforcement resources were scarce and response times could take days. It was also established during one of the worst periods of racial tension in our history and has remained unchanged for nearly 100 years. In the early 20th century, it was used to justify the lynching of Black people at the hands of whites. It was used in 2019 to justify the killing of Kenneth Herring, a Black man, by a white woman in Clayton County. And it was used earlier this year to justify the killing of Ahmaud Arbery, a Black man, by 2 white men. Today, law enforcement agencies are much better resourced and response times have improved significantly over the last century. The necessity for private persons to assist in the pursuit of justice has sharply declined, and there is a profound need that the state finally begin to address laws like citizen's arrest that are too often used to justify violence against Black people in our state. Given the risks on all sides of the citizen's arrest laws, we urge you to strongly consider issuing a written recommendation that the relevant laws on citizen's arrest be repealed and that arrests only authorized when conducted by trained law enforcement officers. Thank you.
Thank you very much, Ms. Dodson. I know Mr. Porter brought up the shopkeepers situation, and that's something that you and I have discussed previously. What are your thoughts about the shopkeepers exception and the history behind that, and what consideration, if any, the committee should give to that issue?
Yeah, I think the issue is that currently what is happening, and my conversations with retail establishments have led me to believe that actually what's happening is detentions and not arrest. And I think that's important to note that loss prevention officers and shopkeepers are not taking physical custody and transporting someone to a judge or a peace officer. We could still, without calling it an exception, Georgia could repeal the state's citizen's arrest law, disallow any private person from conducting an arrest, and still explicitly authorize the use of detention in the context of a retail establishment, a restaurant, those kinds of things where there might be allegations of a particular theft crime that occurred on those premises. A lot of states have shopkeepers privilege. In Georgia, the shopkeepers privilege is recognized in our civil liability. Shopkeepers avoid civil liability for false imprisonment and false arrest if they can prove that either the suspicion of the theft was appropriate or reasonable, or the length of time and the manner of the detention was reasonable. So again, while we don't specifically provide a shopkeeper's ability to arrest or detain in our code, we do provide some ways for shopkeepers to avoid civil liability.
All right, great, thank you. A few members of the committee have some questions for you. Representative Setzler.
Thank you, Mr. Chairman. Can you hear me speak? Okay. I have a couple questions for Ms. Dodson. To my good friend, Ms. Dodson, welcome to our committee meeting again. I want to ask you a couple questions if I could, Mr. Chairman. First to Ms. Dodson, do you believe in due process of law as a foundational principle?
I absolutely do.
Okay. I asked that question because in the Herring case and the Ahmaud Arbery case, although they did get a lot of attention for very important reasons, were the citizens arrest laws of Georgia used to justify those actions after due process worked itself out? Or did the defendant simply make a citizen's arrest claim, which was not able to be substantiated, which in fact upon scrutiny collapsed and showed that citizen's arrest was not a viable defense under Georgia law for the actions that were horrifically responsible for Ahmaud Arbery's death and the death in the Herrick case?
I would say to you that the only reason why we are able to take the position that citizen's arrest was inappropriate in the Ahmaud Arbery case is because we've seen the video. Prior to the public release of the video and the conversations that we're having now, there were, and I want to be clear, that one of the prosecutors that was assigned to Mr.
All right, it looks like Ms. Dodson's feed has frozen. I will send her a text and
Mr. Chair,
make sure she knows about that. And so what we'll do is we will just, when she's back on, then we'll have the committee members, a few committee members had questions. We'll resume at that time. All right.
Mr. Chair, could I just, since she's not available, can I just ask a sort of a
I
parent?
think she's
Chair?
I'm sorry.
She's on. All right, great. We can hear from you.
So sorry about that.
And Mr. Chairman, I asked Ms. Dodson the question because ultimately the point I'm making is people can raise any kind of claim they want to. Ms. Dodson's an experienced defense attorney herself. She's made claims, on behalf of defendants that have not stood the scrutiny of court. And I think just because a claim was made of citizen's arrest in these circumstances doesn't mean they're substantiated, doesn't mean they're legitimate. It doesn't really, in my mind, get to the probity of the broader question of citizen's arrest, Mr. Chairman. And to Ms. Dodson's point, I think she would also agree that as we look in court cases, if you were defending a defendant, would you want the evidence that's brought against your defendant to be probative to the facts of the case, or would you allow evidence to be brought into the case against your defendant that was more prejudicial in nature and not probative to the underlying facts of the case?
Well, I think without starting a debate here, I think that some of the issue here is the prosecutor asserted citizen's arrest in that circumstance. It wasn't defense counsel, to my knowledge, but I know that we're going to have several meetings to discuss and debate this issue. So.
I'm sorry, I know I got interrupted. I'm going to try to make this point while my internet is stable. Just want to say, if you were to review Code Section 17-4-60 and to really see what authority private persons are given to conduct an arrest, I believe that we would not, that is the issue here. The issue is that private persons are given this authority. And that when you look at it, considering Mr. Arbery's case, what they said that was going on in terms of a burglary, which is a felony, the idea about what reasonable and probable grounds existed is subjective. So we can say, in hindsight, what we think about the assertion of citizen's arrest. But I would say that the law currently authorizes someone to pursue another individual on a suspicion of a felony offense. And I would argue, and the position that Southern Center takes is that ability, that authority should only lie with people who are trained on what probable cause is, trained on how to conduct a warrantless arrest, and trained in a way that would reduce the likelihood of violence to the degree that we saw in Brunswick and in Clayton County last year.
All right.
Mr. Chairman, I share the lady's zeal. I think that, and I'll just close by saying this, Mr. Chairman, I do think the idea of reform is a good conversation to have. I just think to suggest, and I know the gentleman, I know the chair is limited in time. There's a series of questions I'd like to ask at some point.
Yeah, thank you for that, and thank you for your understanding today. I know that we have many witnesses lined up, and we are gonna have time for discussion and debate. I'll next call on Representative McLaurin for a question.
Thank you, Mr. Chair, and I'll try to be brief. If this might help in terms of conceptual clarity, and I believe myself to just be repeating things you've said, but I'm trying to do this for the benefit of the committee, Ms. Dodson. My understanding of the conceptual distinctions between a full citizen's arrest framework versus the types of exceptions that are good for public policy, like a shopkeeper's privilege, are number one, the ability to chase somebody or track them down, and number two, the ability to transport that person once in custody to a separate location where that person never originally consented to be. And if my understanding is, if you take those two features away, that the idea of limited detention on premises where a detainee has voluntarily shown up in the first place, and then the suspicion is cabined to whatever happened on those premises, you can erase the fundamental features of a citizen's arrest while still allowing for some limited detentions. Am I stating that correctly?
That's absolutely what I'm saying. Yes, Representative McLaurin.
Okay, thank you. And Mr. Chair, I just wanted to offer that because I think that that could be a helpful framework for thinking about, private citizens using force against other citizens, and what are the clear lines between when we're okay with it and when we're not. That's all I had. Thank you.
Thank you. Representative Reeves.
Y'all hear me? Okay. Thank you, Mr. Chairman, and Ms. Dodson, thank you. I agree with a lot of the things that you spoke about and talked about, but there was one thing that I wasn't totally clear on, and I want to make sure I understand your position on this. You talked about, when you were talking about the use of detention by a private person on private property, and I believe that what you said earlier was that if somebody is not using force, if they're not demonstrating force against you, then a person would not have the right to detain that person. And my question is if I, based on what I thought you explained or what I thought your position was, if I walked into my house and there was a person in my house that was not authorized to be there, but yet they did not demonstrate any force against me. Now, I don't know what's in their pockets. I don't know if they've got all of my jewelry and my wife's jewelry. I don't have any idea, but they're not demonstrating any force against me. Then based on what you said, is it your contention that I would have the right to detain them, or do I just tell them, run along now, get out of my house, or do I have the right to physically detain them until law enforcement gets there? I'd like to know where you stand on that hypothetical.
Yes, I believe that essentially the castle doctrine, or this understanding about what your rights are in your home, is something separate from what we are talking about here. And I would say that while we should and maybe can clarify the rights someone has within their home and particularize obligation to contact law enforcement, there is an argument that someone being in your home and posing a risk to you and your family is the ability to use force. Now, whether or not you use deadly force and what level of force is used would be a self-defense issue and not necessarily a citizen's arrest issue. I do, though, think, for the same reasons that I articulated around the shopkeepers privilege, that it would be consistent with our concerns over citizen's arrest to provide some specific information or authorization for individuals in their home to be able to detain someone until law enforcement arrives. I still think, though, Representative Reeves, that is a detention and not an arrest, and something that is not just a semantics, but there is a significant difference between those two things.
What if it was a car? What if it was my car in a parking lot at a grocery store, and I came out to the car and there's somebody in my car and I don't have any idea why they're there or what they've taken from my car? Do you feel that I have the right to order their detention until law enforcement? Entering auto is a felony, we know that. But under philosophically what you're saying, do you agree that I would have the right to detain them until law enforcement was able to show up at the scene, or do you disagree with my right to do that?
I think that I would reserve the conversations around what detentions look like in terms of what someone feels comfortable doing with another person until law enforcement arrives, or having some explicit clarity in the law around the use of law enforcement, because what I've shared with folks on this is that it's not only for the individual who is alleged to be committing the crime, but it's also the risks that are posed to the citizen themselves. And I would suggest that it would be more appropriate if you were to find someone who is stealing your property or inside your vehicle to be in contact with law enforcement. And should you believe that you could detain that individual until law enforcement arrives, that would not be an authority that was derived from 17-4-60. That would be, again, this issue around detention for law enforcement to respond. And arguably, I don't think that the law prohibits someone from doing that right now.
Well, and I think that the problem from where I'm coming from, and I realize we're going to have a long conversation about this, and this is the beginning of this, but what you've just described is very subjective analysis. And I think that we will run into a tremendous series of problems if we try to address this where subjective interpretation is what we're looking at. And I disagree with you that placing the burden on what a person who may be the potential victim of a crime, on what they feel comfortable with and how they feel comfortable with handling a situation that they walk up in the middle of, which in literally 99% of the time is going to cause a person to flee within 3 seconds. I don't think that we can subjectively look at this and be able to come to a conclusion that properly balances property rights in this. So I'll stop asking questions at that.
All right. Well, thank you very much, Ms. Dodson. What we'll do is we will next hear, I'd ask the committee members if you would take off the raised hand feature if you hit it before, just so I can keep consistent with who has questions. And next we'll hear from Reverend James Woodall, President of the Georgia chapter of the NAACP.
So thank you to Chairman Evstration and to the members of this committee. In February of 2020, Ahmaud Arbery, a 25-year-old black male, was killed while jogging in Brunswick, Georgia. His killers were George McMichael and Travis McMichael, a father and son, who were free for over 70 days before they were arrested for the murder of Ahmaud. Through the criminal prosecution of those murderers were due to the underlying persistence of his mother, Ms. Wanda Cooper Jones, the mother of Ahmaud Arbery. The public release of a video taken by Mr. William Bryan, who is also currently in custody facing charges of that murder, recording the death of Ahmaud, helped generate public pressure to bring attention to this case. What initially brings us here on today is both the McMichaels and Waycross's District Attorney George Barnhill. He initially invoked the citizen's arrest statute as justification for why there should not be any criminal charges in the death of this young man. Georgia's citizen's arrest statute has been in existence in one form or another since 1863, the same year that the Emancipation Proclamation went into effect. Over time, the uses to which this statute has been put have reflected the provision's racist origin and legislative intent. The broad language of this statute has dangerously allowed for private citizens to take the law into their own hands, which would ultimately always lead to devastating consequence. Before I begin, I would like to thank the NAACP's legal counsel and their law fellows, Ms. Alexandra Rowley, DeJuan Norwood, and Nana Osei, for assisting in preparing me for this testimony. And so I intend to speak directly about the history of this law, the specific problems associated with the text of the provision, and the complete lack of accountability regarding this use of statute. And so first, with the history, the original OCGA was codified in 1861 and authored by Thomas Cobb, a lawyer, a slave owner, and Confederate States Army officer. In 1858, Cobb authored an inquiry into the law of Negro slavery in the United States of America, in which he argued his racial stance on the physical, mental, and moral development of the Black race. When the citizen's arrest law was first codified in 1863, the state was seeking to address the growing number of enslaved Africans that were fleeing plantations to join Union forces during the Civil War. This revision of the code empowered white Georgians to replace law enforcement and slave patrols to keep the enslaved Negroes in Georgia in chains. The lynching of Ahmaud Arbery was not the first instance in which the citizen's arrest law was used to support racial violence against Black people here in the state. According to research provided by the Southern Poverty Law Center, in 1868 alone, there were over 300 reported cases of the Klan, the Ku Klux Klan, murdering or attempting to murder Black citizens here in Georgia. Between 1880 and 1930, the Mary Turner Project documents that over 450 lynching murders of Black people. The lynching project has even archived 589 documented lynchings between 1877 and 1950 in Fulton County, Georgia alone. Lynchings of African-American men and women here in Georgia by white mobs making quote-unquote citizens arrests have a particularly gruesome history. On January 22nd, 1912, 4 African-Americans in Hamilton, Georgia, 3 men and a woman, were citizens arrested and lynched, accused of killing a white planter who was sexually abusing Black girls and Black women. On July 25 of 1946, 2 African-American couples were dragged from their car at Morris Ford in Walton County, shot about 60 times by a mob of white men making a quote-unquote citizen's arrest. No one was ever charged with their murders. Although not always explicitly invoked, Georgia's citizen's arrest statute supported or allowed for many of these lynchings. The second is the problems with this particular statute. You see, the racist purposes to which this statute has so often been put are furthered by 2 sets of problems that emerge from the very text and interpretation of the provisions governing citizens' arrest. The first relates to the vagueness of the citizens' arrest provisions requirements for the circumstances under which an arrest may be made. The second, to the means through which the arresting actor is authorized to conduct the arrest. The Georgia Code 17-4-60 provides that a private person may arrest an offender if the offense is committed in his presence or within his immediate knowledge. If the offense is a felony and the offender is escaping or attempting to escape, a private person may arrest him upon reasonable and probable grounds of suspicion. As it currently stands, this provision creates 4 problems relating to the broad set of circumstances in which the statute licenses an arrest. First, the term within his immediate knowledge authorizes an individual to determine whether an offense has been committed through information derived from any of his senses, including information provided by a third party. As such, the statute encourages the proliferation of apprehensions by private citizens on the basis of what may ultimately be flawed information. Second, citizens' arrest of suspected felons, as opposed to misdemeanors, may take place before, during, or after the commission of a crime. Further, a private person does not need to be present at the scene of an alleged felony in order to apprehend a suspected felon. Third, Georgia citizens' arrest statute fails to distinguish between felonies that are immediate threats to public welfare and that those do not constitute a continuing immediate threat. Fourth, 17-4-60 establishes that a private person may arrest him upon reasonable and probable grounds of suspicion, seemingly applied only to felonies. The reasonable and probable cause provisions is problematic because it requires citizens who are largely untrained to evaluate unfamiliar legal standards. The lack of expertise with regards to probable cause assessments by civilians is increasingly significant, given the rise of private neighborhood watch and security groups who rely on guidelines that are overly general and often inaccurate. Finally, 17-4-60 conflates reasonable and probable cause standards, which further increase the risk of unlawful arrests. Whereas brief seizures by the police generally require the police to have reasonable suspicion, actual arrests require probable cause to be lawful. Section 17-4-60's use of both reasonable and probable cause standards may compound the confusion for civilians who are unfamiliar with the difference between the 2 evidentiary thresholds. A separate set of problems, though, arise from the use of force that Georgia's courts have interpreted the citizen's arrest provision to authorize. Although the statute is silent with respect to force, Georgia's case law has clarified that only force that is reasonable under the circumstances may be used to restrain the individual arrested, as well as to compel surrender in response to perceived intent and ability to resist arrest. See Patel versus State in 2005. Importantly, perceptions regarding an individual's intent and ability to resist arrest are intrinsically tied to racial stereotypes that link Blackness with criminality, savagery, and aggressiveness. Another problem arises from Georgia's court's allowance for force to be used to prevent the flight of a suspected felon. courts have upheld that flight as a sufficient basis for reasonable suspicion of a criminal offense, and thus an investigatory stop of the fleeing person. See State versus Smalls, 1992. But an individual's assessment of the risk posed by another individual fleeing from custody is intimately related to the person's racial biases, regardless of whether that person is a private person or police officer. So in general, Black individuals who flee are 1.22 times more likely to be killed by police than whites who flee, with race serving as a more salient factor than others in an officer's decision to use lethal force on a suspect in any circumstance. Private citizens who are subjected to less bias training than officers likely act with similar or greater bias when responding to the perceived threats of harm posed by a perpetrator attempting to flee from custody. The presence of this statute endows private persons in private protection with an expansive jurisdiction, whereas police officers are confined to a particular jurisdiction, thereby increasing the potential for abuse. The last part I want to mention is the lack of accountability. An additional factor makes the citizen's arrest statute even more susceptible to racist use. The lack of any mandatory accounting or reporting requirement for how a citizen's arrest is used. You see, under the Open Records Act, Georgia's police agencies are required to release all public records that do not fall within an exception. See 50-18-70-subsection B2. But this broad release of information is irrelevant if the records do not exist at all. And under Georgia law, there are no documentation requirements for police with regards to citizens' arrest. As a result, it appears likely that only the more extreme miscarriages of justice purportedly justified as a citizen's arrest are noted. This lack of reporting requirements and the problems that it may facilitate was clearly displayed in the murder of Ahmaud Arbery. There is no mention whatsoever of an attempted nor a executed citizen's arrest in the police incident report documenting that murder. With no accountability mechanisms under Georgia's law currently in place, there is no way to record citizens' arrests, determine how often they are made, or document or analyze the disparities present in ways in which the citizens' arrest statute is used. In conclusion, the professed purpose of citizens' arrest statutes is to maintain and preserve the general welfare of the public. There's no evidence that it has served this purpose, and the problems related to Georgia's citizens' arrest statute, up and including the invocation of the statute to justify, though incorrectly, the murder of Ahmaud Arbery, undoubtedly are connected to the racist underpinnings of the legislative intent of this provision, the statutory vagueness that facilitates continued racial violence, and the complete lack of accountability surrounding citizens' arrest. Thank you, Mr. Chairman, for allowing me to share a few words on today. But I do believe that this is an urgent conversation that we need to have. And though it may not have been invoked correctly in the Ahmaud Arbery case, it gave justification in the eyes of those murderers and the district attorney for why Ahmaud is no longer with us here today, and so many others before him. And so with that, I'll yield for questions.
We have two members would like to ask questions, and I'll just remind the members that we also have three additional speakers signed up today. So if you could be concise in your questioning, please. Representative McLaurin.
Thank you, Mr. Chair. So just two very short questions. Thanks, Major, for your testimony. The first is going back to the question I asked Ms. Dotson. And correct me if I'm wrong, what I hear you saying is that a couple of the elements that are unique to citizens' arrest that can be traced back to racial violence, the slavery era from the 1800s, are this idea, number one, of chasing somebody down, and number two, the idea of using some sort of violence at the end of that pursuit, such as either lethal force or, again, kidnapping, taking somebody to a different place. Is that a fair assessment that those elements of citizens' arrest are the ones that could be traced back to the history of racial violence?
Representative, that is exactly correct. And in fact, you can look at the similarities between the provision in 1863 and the Fugitive Slave Law that was written specifically to catch slaves. And so when you say citizen, back then, Negroes were not citizens. They were not even considered human beings. And so when we talk about citizens' arrest, there's a clear distinction as to who's a citizen and who is not. And so when you conflate citizen or lack of non-citizen with Negro or colored or other terms that we've used in legislative history, what you find is that the very notion that Black people, their very being is criminal in nature, then you allow for there to be racist implications. So there is no escape, regardless of if this was invoked correctly or not in the Ahmaud Arbery case, there is no escaping the legislative intent of why this statute was created in the first place. And so to ignore that would be to literally be complicit in white supremacy.
Thank you, Major. And the last question I have is, say that this committee and the legislature were to create or clarify elsewhere in the code a shopkeepers privilege or some sort of castle doctrine style privilege for detention, where, again, there was a limited ability to detain somebody with reasonable suspicion of a crime on premises. Is it your opinion that that sort of limited privilege would be able to escape or at least not be as strongly associated with that history of racial violence that you've discussed in your testimony?
I do agree with that. I believe the shopkeeper's privilege is necessary to maintain, especially on the premise of merchants and retail and even restaurants. And so to be able to define what that actually is and to also extend that privilege to law enforcement statewide. But as far as private citizens who are not trained, who are not certified through the post training certification program, I am of the position, the NAACP is of the position that we would not be supportive of that extension.
Thank you, Major, and thanks, Mr. Chair.
Representative Setzler.
Hey, Mr. Chairman, to the gentleman, I've had the honor to serve on the Judiciary Non Civil Committee for 16 sessions. It has been a focus of my professional life and certainly my life in elected office to maximize the human freedom of all people and fight against anything that would undermine the rights of any individual, irrespective of color, background, age, financial resources, anything. It has been the professional focus of my life. But I do want to ask you a question. I want to say something. I want to separate your words from you yourself, sir, because you yourself, I'm sure, are a fine gentleman. You know, you were made in God's image, as we all were. And we all have dignity as human beings to come before this committee and share our opinions. And I want to honor you for being here as a human being and respect you as a person. But Mr. Chairman, if I could, I think the words of what you said, sir, trivialize the deliberation of this committee, the probity with which this committee looks at the law, and is one of the most offensive, non-probative, reckless statements I have heard in 16 years of being on this committee. The claims that somehow people's skin color makes them objects of I'm struggling to recall your words. Sir, there were about 18 things you said that were reckless and indefensible. And I think it trivializes the real issues that are at play. And I think it candidly undermines the efficacy of the underlying issues we need to address in reforming our citizens' arrest laws. What you
here's Representative, I'm going to jump in. Here's what I need from members of the committee right now: to provide questions to the witnesses. And there will be an opportunity for debate and discussion about the issue later. And I appreciate everyone being sensitive to my watching the clock today so that we can get all of the witnesses in who are signed up. But I would ask, I see Representative Reeves has now put up his hand. Sir, do you have a question?
Can I wrap up, Mr. Chairman, just briefly? I appreciate his indulgence. To the gentleman, thank you for being part of the committee process. It's very important to have these conversations. There are citizens who want to speak to this issue, and I value that more than you know. But I encourage you to go to the root of these issues and not make wild claims as you have that I believe trivializes the real issues that are at play. And I would ask you to do better next time. And I say that in all due respect you as a gentleman.
All right.
Can I respond very briefly?
Of course. And I'll just go ahead and set the ground rules here. I ask everyone to direct questions to the witnesses right now and to respect the witnesses who have taken time to be here with us today to give their perspective on the issue that's before us. Reverend Woodall, yes, if you'd like to respond, please do so.
And thank you, Chairman and Representative Setzler. So what I'll share is that there is no ignoring the reality of what happened in Ahmaud's case, that literally the moment that his last breath was taken, he was called an effing explicative, a racial epithet. Yeah. To look at the Georgia history of how many Black people whose lives have been taken invoking this statute, to ignore that, I think would be an injustice. And so though I hear you, Representative Setzler, I just totally disagree that this law was literally written specifically to keep Negroes as slaves the same year of the Emancipation Proclamation. And so I don't think that there is an opportunity for us to ignore that history. In fact, I encourage us to actually live in our truth so that we can move forward together as a unified community. So that's all I want to say, Mr. Chairman.
All right, Representative Reeves, do you have a question?
Yes, a very pointed question. It's the same thing I asked Ms. Dodson. Reverend Woodall, I want to know where the NCAA's position is as far as if I come home and walk into my house and there is a person unauthorized in my house, or if I am at a parking lot not at my house and I find a person in my vehicle that is not allowed to be in there, does the NCAA have the position that I would have the right to detain that person? So very pointed question.
Yes, Representative, and thank you for that question. The NAACP's position when it comes to use of force and self-defense is very consistent with state law at this present moment. That we believe that every citizen has the right to defend themselves. However, we do not believe that the Citizens Arrest Statute invokes that kind of protection at this present moment, nor of what we are proposing in this kind of conversation. So I think there is a conversation to be had about that, but currently I don't think those two items are synonymous, if you will, and we'll be definitely interested and open to having that conversation moving forward.
Okay, thank you, but you didn't answer my question. Does the NCAA football, does the NAACP have the position that yes or no, if I come home and there's somebody unauthorized in my home or there's somebody unauthorized in my car, do I have the right to detain that person? You did not answer that a second ago. You dodged it, and I want an answer on that. So
currently right now, our position is that you have the right to defend yourself, meaning there is no detainment. And
okay, so is it safe to say that you do not agree that I have the ability or right to detain somebody in my house or in my car without authorization?
You do have the right. You do have the right.
Okay. Well, I think you're giving conflicting answers right now.
No, so currently you do have that right today to be able to detain someone in your home if you have an unexpected visitor. Let's put it that way.
If the NAACP, I'm sorry, go ahead.
But what we're proposing is that any person a private citizen should not be able to detain. That is our position.
So if the NAACP has its way, then I would not be able to detain somebody in my home or in my vehicle. Is that correct?
That is correct, but you would be able to defend yourself using force, any necessary force.
All right, Representative Kendrick, do you have a question?
I do. Can you hear me?
Yes.
All right. Thank you. Thank you for joining us, Reverend Woodall. So I had two questions. The first question is, thank you for giving many of us that needed that history lesson about why the reason for this law was put in place in the first place. So wouldn't you say that because Georgia is 30% African American, and because we're going to have a series of hearings about this very, very important issue, that it's very important to tell the truth, the hard truth, about why that law was put in place so that we can protect all the citizens of Georgia. And it's important for everybody on this committee and listening to understand what that history is so it can shape and frame how we have discussions going forward about what we do with this law.
That's correct, Representative.
And then my second question is with respect to, I guess, to play out what the question that Chairman Reeves asked. So and correct me if I'm wrong, did you say earlier that you did support in your comments that you did support a carve out for shopkeepers, but you're saying you don't support the carve out for if somebody entered the home for them being detained? I'm just trying to clarify what you said and tell me if I'm mistaken.
That is correct. So the challenge with, and to Representative Reeves's point, and to yours, Representative Kendrick, the challenge becomes when you start adding exceptions, it becomes very difficult to be able to define specifically what is quote unquote property. And so if you have a carve out specifically for, private citizens to be able to detain, I'm not talking about use of force, but specifically citizens' arrests, what you would find is that there really is nothing changed about the statute, because then anybody can invoke the citizens arrest law if they have probable or reasonable suspicion of a crime being committed, regardless if they're a misdemeanor or a felony. And then that becomes an extension literally wherever that person is, because property is not defined specifically to the home. So you have your vehicle, you have, other property elements that are added in code. And so though I'm not a lawyer, I do believe that extension would be somewhat problematic.
Oh, it looks like Representative Kendrick, did you finish with your questions?
Yes, thank you, Mr.
All right.
Chair.
Very good, thank you. All right, our next speaker is Pastor Daryl Ford of Icon Community Church. Pastor Ford, are you on the call? Okay, I don't see Pastor Ford here, but I wanted to make sure because I see some participants don't have their names posted, so I didn't know. All right, next up is Christopher Bruce, Political Director of the ACLU. Mr. Bruce.
Yes, good morning, Chairman and members of the committee. Thank you for your time, especially on this important situation. I want to first say that, again, this is a critical issue that Georgians are facing right now. And I stand with Ms. Dodson and Reverend Woodall with their comments, and to reserve my comments as well. I've been in front of this committee before, and I can talk for a while. I actually have a PowerPoint that could probably have a much shorter presentation because I do not want to reiterate. I don't want to say exactly what they said before, but reiterate what has been said before. So if media services could give me the control to pull up my PowerPoint, we can get through this and get to more questions, Chairman.
Yes, please, media services, if we could pull up the PowerPoint. Thank you.
Looks good. Thank you. Everybody see this? Perfect. Let me start off. Well, again, let's go back into the history of this. We know that citizens arrest does have its issues within racist history of Georgia. So it's codified over 250 years ago. This is at a time at the end of the Civil War where we know that lynch mobs and slave patrols are a true thing. Like, this is a part of our history. And it was at a cusp of a era where even Georgia had some of the highest lynching rates in the country. This is actually going on at the same time as the citizens arrest law was happening. And by Georgians during the time to preserve their dominance over Black Georgians, especially in the South. This isn't something that just happened in Georgia. This was happening all across the South as well. So we have other committees that were out there, like the Vigilance Committee, the Citizens Council, and the Ku Klux Klan. Everybody talks about the KKK a lot of times, but there are a lot of other white supremacist organizations that were out harassing and terrorizing the Black community, especially at a time when Georgia had one of the highest numbers of lynchings between 1861 and 1945. And citizens arrest laws, like other laws, really put out that type of atmosphere of saying what you can and cannot do and tried to be used as justification for this. So we talked about the current statute and how it's being used, a misdemeanor versus a felony, and how you're committed to your presence and having immediate knowledge. So we know that for felonies, the private citizen may arrest if the individual is escaping or attempting to escape upon reasonable and probable grounds of suspicion, compared to the citizens who make an arrest who is required to take the arrest to a judicial peace officer, again, with this type of language, without any unnecessary delay. So there are problems with this, which basically you're deputizing a citizenry that really can be using this for racial biases and empowering them to make unsubstantiated arrests. So citizens take on the duties of law enforcement without the same training or oversight that law enforcement has. And it's unreasonable to expect private citizens to know all the nuances between misdemeanors and felonies and that certain type of situations, especially when it comes to life in this situation. So Georgia's citizens arrest laws have had deadly consequences, just like as President Woodall had put out. This isn't the first time with Ahmaud Arbery that citizens arrest has been used. And it won't be the last time unless we actually do something about it. So let's make sure that, again, law enforcement already has resources to handle these type of things. We should encourage our citizens to look towards law enforcement to make these type of judgments. And we spend a lot of money on law enforcement. And I'm happy to have that conversation with you later on about how we can use this money towards other community programs where we don't have to deal with as much crime as we're actually dealing with social services and helping out communities. And preserving this law would not only uphold the racist past that we've had, but the basic inconsistencies that we have in life. So our recommendations, again, repeal the ability of private citizens to make arrests. Instead, we can clarify the shopkeepers rules to detain individuals and suspect for unlawful taking of merchandise or goods without purchase. And then we can clarify the type of force allowed and not allowed when a shopkeeper effectuates a detainment. Told you I'd be briefer, Chairman. So
Thank you.
to answer any questions. I yield to the committee.
Thank you very much. We have a few members with questions. Representative Reeves.
Thank you, Mr. Chairman. Mr. Bruce, thank you. And I know you talked about, you just spoke about how our police have resources and that these are best left in their hands. But I think the whole underlying purpose of a lot of what we're talking about are situations where the police are not able to be present immediately. And so I'm going to ask you the same question that I've been asking. And regardless of what Georgia law is today, I'm getting better at asking this now. Is the ACLU's position that I would be able to detain somebody that was unauthorized to be in my home and or detain somebody that was unauthorized to be in my car? If the ACLU had its way, would I have the right to be able to do that if that person was not displaying force against me?
Chairman Reeves, I've heard you ask this question before, and I appreciate the clarity that you're giving now. I think, especially dealing with the situation we're talking about now with citizens arrest, we would have to go into the nuances between arrest and detainment altogether. So you're saying we're just going to completely do away with not talking about the laws that we are already on the books. You would have to define to me what you mean by detainment compared to what you mean by citizens arrest.
Well, and I think it speaks for itself to hold somebody against their will until law enforcement can show up to the scene, whatever it is that I've just walked in on. Again, I'm not talking about anything complex, just a very common sense scenario. I come home, there's somebody in my house. Can I or can I not detain them against their will until the police get there? I want to know what the ACLU wants